This one, we'll be talking about the arbitration ecosystem and arbitration landscape in Bombay.
Bombay, of course, is a great market to be in.
But that is something which we keep hearing that it's a bubble, it'll burst, it'll come down. But it's all been somewhere up and down. So I think there is. I mean, if there is supply, there is also demand. It's
The Fort area, which is the premium South Bombay area, that's is from VT to Kalagoda. The Bombay High Court is the epicenter there. You have beyond that, you have Nariman Point, you have Marine Drive. All big hotels are there. There is IMC, which
really have three arbitrators. But with the rising costs and in terms of what arbitration has come to today, people are preferring a sole arbitrator. As
Someone who lives in South Bombay, the location is good beyond Bandra for him. In commercial law, which sectors are dominating the Bombay dispute landscape?
I'd say the real estate.
Hello and welcome to the 9th episode of the ArbCast podcast. It is a matter of great privilege that almost on a weekly basis that we have episodes rolling out. And soon enough, in my introduction, I will not have the need to mention which episode number it is. For this one, we'll be talking about the arbitration ecosystem and arbitration landscape in Bombay. This is of great value to people who are contemplating Bombay as a seat of arbitration, or that are contemplating a career in arbitration in Bombay, or are just interested to understand as to how dispute resolution works out in the financial capital of India. And this conversation is only enabled with the type of guest that we have on. Today is another such episode where we have not just one, but two guests. I'll be firstly introducing Mr. Rohit Lalwani. He is a practicing counsel on the original side of Bombay High Court with over 9 years of experience. He focuses on commercial litigation and arbitration. Alongside him, I'm also joined by Rushabh Vidyarthi. He also is a practicing counsel of the Bombay High Court, and he also has commercial litigation and arbitration experience. Mr. Rohit Lalwani, as I mentioned, has 9 years of experience, and Mr. Rushabh have over 5 years of experience. And I must mention to our audience that this is the third time that we are both together having a conversation. The first time we had a conversation was not even a conversation, was when we first time we met was at a moot court competition in Bombay itself, the NMIMS moot court competition on arbitration. And both Mr. Lalwani and Vidyarthi were the judges, the arbitrators for that particular round, the first round of the competition. And on a lighter note, they both were giving me a lot. But the tables have turned today because today I'll be grilling them with some questions myself. So I just want to say that thank you so much to both of you for taking out time and being here. And I'm certain that today's conversation will add a lot of value to our audience.
Thank you. Thank you for having us here.
thank you very much for having us here.
Yeah. So to begin the conversation at a very fundamental level and a very general level, since you both practice in dispute resolution and sometimes come across domestic arbitration cases and international arbitration cases, what is your outlook on the arbitration ecosystem in Bombay, in particular, where the arbitration is seated in Bombay?
Should we want to go first?
No, you please go first.
Okay. So the arbitration landscape in Bombay, so there are, of course, different ways to look at it. One, of course, for a practicing lawyer, and second, of course, it is for a party, a litigant, who, in that sense, chooses Bombay as a seat for arbitration. First, maybe as a lawyer, Bombay, of course, is a great market to be in. Commercial capital, as you said. Of course, over the years now, Bombay, in that sense, many other cities have come up. Commercial transactions have increased. But Mumbai still remains the epicenter of things. And the Bombay High Court still is one of those few high courts which has the original side. Usually the original sides are in other cities or in other states are the district courts. So Bombay is still one of those remaining courts in India which does have an original side. So therefore, any arbitration application which goes to the court of original jurisdiction, therefore in Bombay goes to Bombay High Court. And therefore it becomes much more interesting for a lawyer, because people who are practicing in the High Court at Bombay will vouch for this thing that the Bombay High Court, it's a very different vibe to really be there and practice law. The intellectual uh, sort of intellectual understanding and how things function is very different from the rest of India. Not that I practice all over India and I can say something with absolute conviction, but Bombay, of course, is always a very distinguished place to practice law. Arbitration in Bombay is a very good career, is a very good practice. Someone who is looking forward to sort of pursue that. Um, uh, Now, typically, how do you really start an arbitration dispute? Um, there is going to be an agreement. There is going to be a contract. One party may be aggrieved by the actions of the other party, and eventually an arbitration agreement or a clause or whatever nomenclature you like to give it gets invoked. If most of the times, if it's not institutions or corporates, etc., most of the times when you invoke arbitration, no one really bothers to reply and accept the reference. Of course, no one wants to go and litigate. So people try and delay it and extend it. And therefore, we land up after 30 days before the High Court of Bombay under Section 11 of the Arbitration Act. And there's how things start. Now, Rushabh, of course, will highlight what the law recently has been laid down by the Supreme Court, which now, in that sense, blocks every argument that you can take in Section 11. In a way, the only argument is that whether there's an agreement or not, and everything from stamping, etc., everything now is out. If 11 is filed, a judge predominantly will, at the very first instance, tell you, please tell me who do I appoint as arbitrator. So this is how it starts in Bombay. Now, we, at least in Bombay, what I understand is that we are lucky as counsels and lawyers. We get an opportunity to be appointed as arbitrators in ad hoc, references. Uh, a lot of times, disputes are not very high value, where retired judges are not preferred or senior counsels are not preferred. The junior members of the bar get an opportunity, and judges, in that sense, exercise discretion, and whoever they deem fit, they sort of appoint that lawyer or counsel, solicitor, etc., as a arbitrator in a Section 11 order. So that's how it starts in Bombay. Uh, of course, then how it continues is we'll jump to that. But if Rushabh wants to add something to this uh, process, then
Yes, so as Rohit really pointed out right now, is that it of course starts with your inception, whether it be Bombay or it be any other city for that sense. It has to be, of course, by way of an invocation, and thereafter, if parties consent and they appoint an arbitrator, which also happens, but sometimes, as you generally see, most of these are money claims, and the respondent or the defendant, as you may say, is not very savvy to really quick to give consent to arbitration. So in that sense, they would want to delay it as much as possible. So not that in all cases, although despite the law is now very clearly spelled out, despite getting a concrete legal advice on how appointment can take place, there are people who either are unwilling to consent to arbitration at the stage of invocation, or they are unwilling to, at many times, consent on a common name of appointment. As to, now what earlier used to happen is that when this trend started, at least, they used to generally have three arbitrators. But with the rising costs, and in terms of what arbitration has come to today, people are preferring a sole arbitrator as an arbitral tribunal. So instead of having like a full member tribunal, which is a three-member tribunal, So people are generally, for some reason, unable to agree on a common name, or unable to really, go forward and consent. So that brings you to the appointment stage. And generally, most of these appointments happen through the High Court, despite, arbitration now being very clear on how the appointments can really happen. So at Section 11, I think last year we saw, so earlier Section 11s were also contested. There were, in fact, on account of pendency, there were matters which would not really, come up for hearing, which, because there were a lot of Section 11s which were contested. There were Section 9s which were contested. The roster of the judges was such that a single judge would be dealing with a Section 9 petition, which was your urgency, your Section 11 for appointment, some of which went contested, and even Section 34, which of course is not an appeal, but it's argued as if it is an appeal in terms of the time that it consumes. Of course, now counsels, lawyers are all privy of the fact that, you can't really endlessly go on arguing even a Section 34. But under the garb of calling it patently illegal, or under the garb of raising any of the challenges which are available under a 34 court, you try to consume that amount of time. So that used to, so that sphere, at least after the lockdown, we saw that, the appointments would take time. I mean, today if you file a Section 11, the other side would come forward to file a reply. All of this, ultimately this may go on for 8 months or 9 months. I have in fact had a matter where the Section 11 petition was, application was filed in 2019, and we got an appointment order in 2022. So that is, of course, the COVID delayed it quite a bit. But of course, that is some sort of a delay for, you look at arbitration to get over within 6 months. At least that is the common perception for a lot of people. So all of this got changed by, of course, that Constitution bench judgment on the aspect of stamping, which is interplay, and which was followed by Justice Pardiwala last year in SBI General Insurance versus Krish Spinning. So now what the court looks at least since last year's August 24, is only the existence of a clause. So today, the way the Section 11 matters are argued in court is very different from how they used to be argued 2 years back or prior to the judgment, wherein people used to try to file a reply, do make all sorts of arguments on limitation, on say accord and satisfaction, or any of those mixed questions which would, sort of try to, under the garb of knocking the dead wood, at the 11th stage. So that has really stopped, and the courts are very firm. In fact, we have the, judges who are extremely firm on saying that the moment you admit to having signed an agreement, all your contentions, including anything possible, has to be taken before the arbitrator. So you can raise your 16. So that really has now given more, it's underscored the concept of your competence principle, which says that the arbitrator is really the master of granting interim relief, of ruling on jurisdiction, or perhaps on, and of course the master of his own evidence. So that really has empowered it, and the Section 11 applications are now, I mean, you get an appointment within a month or two, by, of course, counting everything, your stage of removing defects, or to your stage of serving the other side who's not appearing or who's trying to evade service. Everything, it takes 2 or 3 months, and now you have an appointment. So that, of course, is very, very, comfortable for a litigant, wherein he at least sees an appointment immediately, and thereafter the arbitration can proceed at its own pace. Because in court, you really don't have that control. There are matters, 40, 50, sometimes 60 matters listed before a judge. You don't know what serial number will you be at. Somebody who's at a higher serial number or an item number than you would perhaps not go on with the matter. Somebody would go on for that matter and endlessly argue. So you are really not, in that sense, in any form of a control. But in arbitration, you have that control, wherein, you could request, it's a one-on-one, just how we are talking today. It's that sort of a comfortable platform that you have, where you can, sort of speak to the arbitrator, say that, this is the urgency, please list it, and dates are accommodated. The matter, the date on which the matter is fixed, unless even except a contingency, the matter will be heard, your trial will progress. So that is a big difference that has happened in appointment of arbitrator. And judges are, even now, after, that judgment of Justice Banerjee, which says that arbitral tribunal has equal powers to a court under Section 17 and 9 are that way same. Judges are unwilling to even hear elaborate arguments at the stage of Section 9. So that has really changed a large part of it. And in the last 1 year, we have, as practicing lawyers, seen a very, very big and a very positive change, to which, you file an application, you get, as long as your invocation is correct, and as long as there is an existence of an agreement, you have an arbitrator appointment, and the matter then goes forward. So that is something which has come out very positively. And as Rohit pointed out, arbitration over here in Bombay, you will find arbitration from from the lower bracket of the fourth schedule to the highest bracket of the fourth schedule to judges charging their own fees. So it's in that sense become, you will find all sorts of arbitrations over here. And as he rightly pointed
There's a
out, you will
market for
have,
everything.
right. So you will have young counsels as arbitrators. You will have senior judges of the Supreme Court or the High Courts as arbitrators, who are in that sense master of how trials take place. To you having mid-sized advocates, or advocates or senior advocates as arbitrators. So that way the appointment spans almost everything, and judges are sort of, they are pushing to appoint young lawyers, or at least lawyers who are a little bit in practice, who have handled those sorts of matters into to push them to be arbitrators, which also is a positive change, because as I mean, there are we must you must have seen it in the public domain. There have been many legal luminaries sort of criticizing that India is the only country which is somewhere stuck on to appointing judges as arbitrators. So that you see in Bombay is not really being strictly followed, depending on, of course, the quantum of the claim and the requests that the judges receive. There are counsels appointed, there are also judges appointed, and it's in that sense all sorts of arbitrations you'll get to see, from people disputing on a sum of rupees 2 lakhs or 3 lakhs or something, to it going into hundreds of crores. So that is a very big diverse factor which you can see in Bombay as arbitration progresses.
In matters where the other side is not appearing at 11th stage, uh, now judges have taken an approach where they are, in those matters where the other side is not appearing, they're appointing institutions as arbitrators. So, I mean, one of the, like the MCI, the Mumbai
Right.
International Commercial Arbitration Center, is one of them. So judges take that approach that even if the other side is not appearing, to show all fairness, I won't go to a retired judge or an individual counsel or an advocate. We'll appoint an institution so that everyone is protected. But the appointment should happen. The matter has to go ahead. So that's how things have changed in Bombay at the stage of appointment. Earlier, it used to even be a task for the arbitration to start, because, as Rushabh pointed out, it used to be contested and heavily contested, which would consume a lot of time. But now things have become pretty different. Good for, I mean, the change is good. Uh, yeah. And once, of course,
And in
you get
terms
a
of
point. No, Rushabh, say.
no, please no, please continue.
No, I was moving on now after 11, but if you want to add something to 11, then
Yeah, so
please.
it just thought on what Rohit said is in terms of the institutionalized arbitration. So you don't typically have only an ad hoc arbitration, and this is something which has been followed over a period of last 6 months to 1 year. Is that there are many cases where you see that there are individual parties fighting an institution, and these are simple matters, from finance agreements not being adhered to, or loans which are in short not being paid, etc. What the High Court has done is they have to oversee that the ex parte, if at all the arbitration has to even proceed ex parte, it proceeds with some sense of a channel. So it's not that the arbitrator is just ad hoc arbitrator is appointed, and thereafter he chases on that the respondents are not appearing, or something of that kind. Is service complete or not? So the MCIA in that sense has been appointed in numerous matters, and I am a recipient of two of those arbitrations where I'm handling as an arbitrator. And they have that gives a sense of a hope and a sense of a trust even amongst parties. For instance, in one of those arbitrations, as I recount from my personal experience, the respondents have not been appearing. So you have an institution which is really following up and ensuring that the services are complete. There is that arbitration which moves in a transparent manner. It's not that one of those times one of the parties served through WhatsApp or through email or through a courier, and somebody doesn't turn up and the arbitration goes ahead, and tomorrow when the award is passed, the disgruntled party may say that, look, I left that address long ago, I am not staying there, and how could this happen? And thereafter the parties have to go through that whole round. So institution also, MCI, I feel there's Miss Niti Sachdeva, who's the secretary of the MCI, and they've been doing a lot of fantastic work in terms of ensuring that amount of transparency, where you have a bridge between the arbitrator and between the parties, where if the parties are really suffering from any sort of they are not able to communicate with the arbitrator, or they feel that the arbitrator perhaps is a little whimsical, or we are not really able to connect in that sense, you have a bridge where you can go to the institution, you can approach the institution, and sort of at least take care of all your logistical and administrative functions. So that also brings in a sense of confidence and transparency. And the most important thing is that after going through this entire process, when you say that this has to be done in a speedy manner, it shouldn't be that the award is set aside, or because some party cries foul by saying that, look, I was not treated fairly, or I was not, because see, ultimately when you pass an award, or when an award is passed, one of the parties is going to be not happy with it. So to ensure that a right party really gets that award and that is implemented and executed, it's very important that the transparency or the impartialness is really reflected in the process. So that way MCIA and all those institutions which are there are also doing a very good job, and that they have been inculcated with by the Bombay High Court in terms of appointing where there is a ex parte arbitration, or where there is nobody appears at the section 11 stage. So that also is a type which is forthcoming in Bombay. So that's something which is encouraging, and I feel that must be given impetus somewhere.
Yeah, well, there's a lot to unpack from both of your answers. And usually, when guests give answers to our questions, I don't usually write notes. But for this one, because a lot of information was being thrown, and I did write notes. So there are some five, six takeaways from both of their answers that the audience should take note of, which is firstly on the aspect of delay. It is not necessarily that just because both parties have consented to arbitration, they are pro arbitration. Obviously, the claimant will be more pro arbitration than the respondent, and the respondent will like to delay the arbitration. This is a strategy which I personally believe is not gonna give you any results, because the ecosystem is such that the courts will see through this and the arbitrators will see through this, and in the end, eventually, it will show up in the award. So in arbitration, unlike in litigation, delaying the dispute may not necessarily be helpful in my opinion. But I just want to say that because I've been around the Delhi ecosystem, I must say that this is not exclusive to just Bombay. We have such issues in Delhi as well. Also, we have noted that throughout India, people have started to take cognizance of the fact that a three-member tribunal can be very expensive, even though it is more easier to constitute, because you have both parties appointing one. And like both of you mentioned, that it is highly unlikely that both parties will agree to a sole arbitrator. But a sole arbitrator is more lucrative because you're only paying for one arbitrator instead of three. And another very insightful thing that Rushabh talked about, which is something that the audience must take note of, that even though Bombay is the financial capital of India, it is not that only the biggest of big disputes are being adjudicated. As we mentioned, the lowest bracket of Schedule 4 to the highest bracket of Schedule 4 is being adjudicated. And also the fact that in this particular series, we have established that in India, it is very peculiar that only retired judges are being appointed as arbitrators in big commercial arbitration disputes, which is perhaps only peculiar to the Indian landscape. But as Rushabh mentioned, that is changing with time. And the example is sitting right in front of us. As he mentioned, that he is being appointed as an arbitrator in two institutional arbitrations. So if it's an institutional arbitration, the parties are very sophisticated. And Rushabh only has 5 years of experience as a lawyer. So we are seeing a change happening, that parties are understanding that it is not necessarily that just because they're retired judges, they are more capable of adjudicating a dispute. And also something that Mr. Lalwani talked about, which is of institutional arbitration. So in India, majority of the arbitrations are ad hoc. But we just discovered that in Bombay, especially, people are understanding the benefits of institutional arbitrations. So I would just like to follow up on that particular point, which is that if you were to compare institutional versus ad hoc arbitration, which supersedes the other? Like which arbitrations are more than the other?
As in what is actually happening, or
In
what
your
is
experience.
what is desirable.
What is actually happening? Desirable, I think we can all agree that institutional has a lot
Ad
more.
hocs are, of course, ad hocs are, I think, more, if I would
So ad hoc is
yeah.
of course more, because institution in that sense is also an added cost for parties. So not all parties are willing to go by with that. And the other thing is it's just a matter of, say, habit and culture. In Bombay, all these years you have seen ad hoc arbitration. So people feel that they perhaps don't know that whether there is actually any need of an institutionalized arbitration, which they realize later on that there is in fact, of course. So there are of course added advantages, but it's about a habit that has formed. I mean, in lawyers, in litigants, where there are several litigants who have, or PSUs for instance, who have litigated for years. So they perhaps are, this institution is a new concept in terms of, at least that has come to Bombay and even to India. So when they have previously litigated and they've previously, gone by ad hoc arbitrations, they perhaps feel that what is the need for an institution and why do I have to pay more fees or something of that kind. So in practicality, as of now, ad hoc is something which is of course more dominating in its numbers. But and I think Rohit also will agree with me that institution has its own advantages, which really can't be given a go by. So perhaps I think that also, see, every trend takes a little bit of a time to set in. Today we are talking and we are exchanging an experience. Tomorrow there will be two, three such more appointments and people will exchange their experiences. So that is perhaps with time that you will have people, just think back. And arbitration is something which I think Justice Nariman in one of his speeches said that it's a crab-like structure where there are, two steps forward, three steps backward. So it's like, in terms of the legislation, it's been all over. So that we all learn with something new, that has been coming up. Be it your issue of seat versus venue, or your stamping, or your appointment, or whether the order is a judicial order or not. So it's perhaps been all over the place, and to keep track of the law is something which is I think a feat. So that with trend, and I think with changing times, that will happen. Another thing. Right. So in terms of three members I was talking, it's not only the fees or the cost that goes up, that of course goes up, but it's also your time. Because if you have a three-member tribunal, you perhaps in most cases, as me and Rohit have seen, is that they are all three judges or perhaps one of the senior counsels and a judge or something of that. To match dates in those matters becomes a task itself, and therefore 6 months, there are dates which are given 6 months down the line. So there's no possibility of the arbitration really concluding in 6 months, because you will generally have one Supreme Court judge, one former Chief Justice, or a senior counsel, and for them to map dates together and to come forward for a whole day is something which doesn't really happen on a very sort of in a very easy manner. So that is something which also is a challenge in a three-member tribunal.
Yeah,
This
and
in fact,
yeah, yes, please,
sorry,
yes. No, no,
please,
please.
Harvey. No, go ahead, ask your question.
I just wanted to point out certain things. So we spoke extensively about Section 11, and this podcast is like dedicated to the practical insight into arbitration. But for our audience, there are two judgments which the audience for Section 11 must take cognizance of, which is the SBP case, which held that under a Section 11, the court is not having a jurisdiction which is adjudicatory, but only supervisory. So it's not that you can adjudicate on the merits of the arbitration agreement, whether the agreement is valid or not. All that you have to see is that the arbitration agreement is existing. Whether it is valid or not can be adjudicated by the arbitrator himself under Section 16 during the arbitration. So if in case you have an instance where the judge is getting into the merits of the arbitration agreement, this is a case that one can cite because it is only supervisory and not adjudicatory. Another one is, which I think Rushabh mentioned, about the stamping case, which is the in re unstamped arbitration agreement, which echoed this particular judgment. So it ensures that the role of the court in an arbitration, especially in appointment stage, is as limited as possible. So these are the two judgments which the audience must take cognizance of.
In fact, something that really that I want to share is something that comes to my mind always. I mean, this sort of echoes when this entire approach about now, arbitrations, the appointments being, so streamlined and things moving so fast. A very celebrated senior counsel in Bombay, Mr. Janak Dwarkadas, once said that commerce cannot wait. So very iconic, I would say, that commerce cannot wait. This was something when he was arguing in a matter related to arbitration, and he said commerce cannot wait. So therefore, I mean, arbitration is essentially commerce. It's these are commercial transactions, these are commercial disputes. You cannot have that much time delays. A party has to have remedy versus a civil suit. Why do people opt for arbitration? Is of course because of the time consumption, the lesser the time period. So yeah, I mean, in that sense, the appointments have now moved faster. Bombay, in that sense, is much quicker and better. The landscape has changed. But yeah, I mean, if there is anything else that Rushabh wants to add, and or any question that you have.
No, of course, that's it. Because even for parties which are sort of international parties, or which have their base internationally, but also are parties which are having some sort of a merger with companies here. For them, ultimately in litigation, if they are not able to get reliefs, or they are not even going to get, I mean, get relief in the sense not able to approach the court and get some sort of an order or get some sort of a hearing, it's really going to affect business. So that's exactly what Rohit mentioned, and he's I think I fully agree with that. That if you don't have a litigation which is fast, your business and your investment will really suffer, because very often they're not undesirably, but parties end up in litigation in most of those projects or most of those commercial undertakings.
Yeah, but it is good to know that at least in Bombay, things are expedited, at least at a Section 11 stage. Now, whether does it happen at a Section 9 stage or Section 34 stage is what we'll explore in the proceedings of this episode. But I think I want to move to a different segment, which is that we have spoken a lot about the procedural aspect of arbitration. I want to talk about the nature of the dispute itself. So we do know that not every arbitration is same. There are sector-specific arbitrations. For instance, there are construction arbitrations in which specialist lawyers in construction arbitration are being appointed as arbitrators and counsels. And then there are different sectors like banking and banking and finance, banking and insurance, and also money in time arbitration, etc., etc. And Bombay is very close to the coast. So you have many time disputes being adjudicated in Bombay also. So my question is, given that you practice primarily in Bombay, what sectors are you seeing which are prone to be adjudicated in Bombay, not just in arbitration but also litigation? In commercial law, which sectors are dominating the Bombay dispute landscape?
I'd say the real estate. Real estate is really big in Bombay. Every second building in Bombay is going for redevelopment. Every ad interim court in Bombay is seized with some urgent matter with the developer, the society, and there'll be some part of the society members who will be opposing to the appointment of a developer, or there'll be a rival developer. So real estate is something, land disputes, development contracts, development rights, these things. I would say Bombay primarily, this is the top layer, I would say. And then of course, the overall, there is insurance, there's banking, um, loan disputes, um, all the regular commercial, transactions, agreements. I mean, startups who enter into agreements, all these. I would say all. Then there's a variety of commercial transactions that happen in Bombay.
Yeah, may I just have a follow-up question to that? In terms of territorial understanding of where the disputes are coming from, is it just in the location of Bombay, or do we have disputes coming from different parts of India just because Bombay is a more advanced jurisdiction?
No, I mean, essentially, Bombay will have what is in and around Bombay.
Yeah, but in an
But
arbitration, like with our parties who are not from Bombay, let's say southern part of India, but
yeah,
choosing
yeah,
Bombay.
yeah. Yes, absolutely. So there are, I mean, for instance, contractors, etc., who undertake projects. Many of them are based out of Delhi, Gurgaon. Many of these, where, I mean, you are seated. Many of these people are, a lot of consultants are in Pune. So all of these people, I mean, when they have to invoke, many of their agreements in that sense do have Bombay as a seat. So they have to come here. So yeah, it's all over. It's from all over the country. But real estate disputes, of course, you will find the parties more or less
Arise
from
out
Bombay.
of Bombay.
Yeah,
Correct.
and real estate dispute, if I may just say that my own building in Bombay is being redeveloped as we speak, and my family has been placed to a different building altogether. And staying on the topic of real estate, which is that in Bombay we are seeing a lot of buildings being redeveloped, and there's a real estate boom, which is not entirely good because whenever there's a boom, the market becomes a bubble, and eventually that bubble bursts. And you will see if you agree with me, that in the next few years you will see less projects happening because there will be a market supply where the supply has gone more than the demand, which is like what one couldn't think that will happen in Bombay. So do you think that will happen in real estate, where the bubble will burst of Bombay?
So
I
supply
don't.
Really is not really a problem. I think the supply has always been adequate and people are more than willing to buy. The problem in real estate in Bombay particularly was the price. So everybody wants a house, everybody wants a place. Even in one family, if you today ask a family of say four people whether they would want to invest in another house for their occupational use. I'm not even saying for renting it out or as an investment. For considering that this is a metropolis, people will agree and they say that okay, fine, there are two people who's just getting married, perhaps he wants a separate house, would not want to stay in the elongated family. So in that sense, supply has not been a problem, but the skyrocketing rates in the real estate of Bombay are something which are a problem. So that, of course, and I mean, we are really not experts to comment upon that, but that is something which we keep hearing, that it's a bubble, it'll burst, it'll come down, but it's all been somewhere up and down. So I think there is, I mean, if there is supply, there is also demand. It's not that the demand is not, and there is some sort of a oversupply or something of that kind. The
It's also
skyrocketing rates were the issues.
it's I think also the location of the houses. You can of course afford a house and buy a house maybe somewhere deep in the suburbs, but it's the location where you are. Like for instance, why there are so many redevelopment projects happening is because people who are living in those buildings, they don't want to go somewhere beyond. So if today the municipal corporation is sort of giving them a benefit of additional space, if they redevelop a building, either they redevelop it themselves as a society or they get a developer, etc., they would want to stick to the same location, because in Bombay, of course, we all know infrastructure issues, traveling is an issue. So yeah, it's more, I mean, I don't know, supply demand. I don't think so. Any matrix really works in Bombay. It's just the location. If the location is good, you have a easy life. That's all that matters.
Yeah, and as someone who lives in South Bombay, the location is good beyond Bandra for him. But that's on a lighter note. But since you spoke about infrastructure, so let me just mention something that I was watching an interview of Mr. Rishabh Gupta. He is a barrister and advocate in India who practices in international commercial arbitration. And he said that when we talk about India being a global hub of international arbitration, we cannot just talk about India having pro arbitration judgments and judges. It is also the city's infrastructure, which is very important because you're having people coming from outside. We need the right hotels at the right location. So, my next question is, how does the city's commercial and legal infrastructure support Bombay as a seat of an arbitration?
I would say as of now, Bombay is good. It's like, I think it's quite rightly placed. I mean, if the Bombay High Court is today in the Fort area, which is the premium South Bombay area, that's is from VT to Kalagoda. The Bombay High Court is the epicenter there. You have beyond that, you have Nariman Point, you have Marine Drive. All big hotels are there. There is IMC, which is a very old institution. There are many such institutions that have come up. MCI is what we were talking about. So I think as of now, the infrastructure, or at least how things are placed in Bombay, are great. They look good. It's convenient because you can hop from, say, even if you're in a lower court, or you're in a high court, you can hop from one hearing to another in an arbitration, which is in a five-star hotel, because it's all nearby. I don't know what the future holds, but as of now, I think it's quite decent.
Rishabh, if you have something.
Right. In terms of space, I don't think there is any problem in Bombay per se. Of course, if you're talking of logistical problems, there are. I mean, if you have people coming in from the airports and you call them towards the main area where the High Court is situated, time-wise, but now there is sufficient infrastructure as well in terms of
Yeah.
your roads, the coastal road has come up, for instance. So that is not a problem. And Bombay has been very, I think, adaptable to where arbitration, from having a dedicated arbitration hall to doing arbitrations in five-star hotels. There is absolutely no dearth. So that in that sense there is enough supply. There is enough measures for everybody.
In fact, very relevant in the whole, this relevant to our topic, to entire the practical aspect of the Bombay landscape. In Fort, there are buildings, or there are centers, or there are offices which are now converted, which are specifically used for arbitration. So someone who has an extra office space, say a big conference room, or as an office space which can be converted into multiple rooms, they actually now rent out by the hour for arbitration, and it's a very booming business in the Fort area. At least there are many such, centers, and they're all very fancy. It's not just, it's just a plain office. There are actually very fancy centers which have good equipment for even, video conferencing, etc. Have refreshments available, and that way the ecosystem has been very nicely placed. It's developed over the years, and it's very nicely placed right now.
Yeah. Also, I just want to have a follow up on this question, which is that a lot of people who are not from Bombay and never been Bombay, they look at Bombay as a very expensive city. So there might be parties who have this notion, and they may think that their dispute is not that much of a high stake dispute. So, do you think that arbitration in Bombay is only accessible only to larger commercial entities, or it welcomes disputes which are not that of a high stake, of a high value?
So strictly, I don't think that I mean, of course, Bombay as a city is expensive. So when you are looking at arbitration in Bombay, you have to add those costs of perhaps, all your logistical and those basic costs of being there to do the arbitration. But in terms of the costs, I think there is absolutely not the case. As we said, counsels are appointed as arbitrators. They all abide by the schedule, and happily so. So the schedule is pretty reasonable. The fourth schedule, as you see, for in terms of your costs of arbitration, etc. I mean, otherwise, of course, if you compare, it depends on what you compare it with. If you compare it to a city, perhaps, which is really, in that sense, rural, or I mean, not a city, but a town or something of that kind, then it might be expensive. But I think that's really come off in all places. So I don't think per se it's an expensive affair. But of course, it's very subjective. But in Bombay, at least what I understand is that you could get good quality legal aid, good quality legal services, and of course, I don't mean the legal aid of the High Court, but you get a good quality of lawyers in every sort of budget bracket, because there are young lawyers who are good at what they do, but they are perhaps charging less fees for the sake of getting an exposure themselves. So that way, that is really not a problem. I mean, even the legal aid lawyers are really, they do the best of whatever is to their abilities. So in that sense, it's really not a problem. It's all subjective, and I don't think it's something that somebody is, it's absolutely unaffordable for somebody to come here and be like, oh, I can't even afford the first two stages, or I can't really pay fees, or perhaps afford administrative costs. But of course, you have to add it to the living standard or the living style of Bombay. But it's not something which is impossible at all. In fact, it's a very arbitration friendly place, and the legal services provided by, I think, a lot many of those lawyers who are in the bracket, say, of me, or Rohit is of course relatively senior, but even in that bracket is something which is I mean, those lawyers do come forward and try to give the best of the services, and it's not something that you'll get some very rudimentary service just because you have a lawyer which is not charging you in that Bombay rates. So that's not
But
really a problem as such.
but also, if you notice now, things have also become virtual. Like, I think it's a couple of weeks ago, I was doing a cross examination. My witness was somewhere in Kanpur, and things have become flexible. It's not necessary always, a party has to travel, or things have to logistically, you have to bear those costs. A lot of tribunals, a lot of arbitrators are flexible. Of course, there are various safeguards that you have to, ensure when, you're doing some virtual hearing. Like, there was someone who was accompanying the witness there to sort of, see if he's not being tutored. But it's become flexible. The cost can come down. It really depends from situation to situation. But it's not inflated to a level where, parties or companies or institutions or individuals can't afford it.
Yeah, that's good to know. And the reason why I asked these two questions was I was recently having a conversation with a litigant who happens to be a senior litigant. And he told me that I get a lot of matters to be argued in the Allahabad High Court, but no matter how much they pay me, I will not go there because I went there once and the hotels were horrendous. So it's like you need the right infrastructure, you need the right amenities to have a good legal infrastructure. But this was on the sectorial aspect and infrastructure aspect of Bombay. Going back to the procedure, we extensively talked talked about on Section 11, which I don't think we need to discuss any further. But staying on Section 34, which is the most contentious section of the Arbitration Act, because that is where the parties capitalize the most on either setting aside the award or delaying the process of enforcement. And you have very unethical things that happen. I personally have experience in the capacity of as an intern in law firms, where parties are using everything under the bus to set aside the award, which is not very ethical and contrary to the purpose of the act. But my question is that the in such a situation that the onus is on the judges to ensure that such endeavors are not met. So my question is, in the Bombay High Court specifically, how are judges approaching a Section 34 application? Can any Tom Harry file an application like that?
See, before going on this question, I mean answering your question, my caveat is that uh, the arbitrator who's appointed or your tribunal, it's purely on a party's luck, I would say, in the sense how that arbitrator or the tribunal will pass an award. Um, if your if your tribunal is really of a sound commercial uh, understanding, you will of course have an award which will be very very in line with how things should be. But if you get like a wrong tribunal, now that's purely on luck. I mean, it's humans at the end of the day. And if an award is passed, it's stuck. Basically, what I'm trying to say, in 34 now, it's become so narrow that for everything the answer is that it's an arbitrator's interpretation of a dispute, of a contract, of a transaction. If it's a plausible sort of interpretation, or his decision is plausible, possible, uh, can be sort of possible, it is still upheld. So it's very difficult to come out of an award, is what I'm trying to say. So a 34 in that sense is very narrow. It some I mean some amount of luck is important with your arbitrator. Uh, if you get the if you even if you're right on merits, but an arbitrator has taken a view which is possible, you may still suffer a defeat in 34. And of course the approach of the courts now has become very strict. uh, Previously, Rushabh pointed out that the 34s were being argued as appeals. Still people make that endeavor to do, because of course there you're fighting to the very last moment for your client. But now I think judges know where to cut it. There is a designated, in fact, before the hearing date is fixed for final hearing, both counsels will be sort of asked how much time you all are going to take, and it's recorded in the order also. So in a way, you're bound by it. So you can't go overboard. So say for instance, you will require half an hour, you'll require an hour. You sort of will have indicated that, so you have to stick to it. Earlier there was just, I mean, it used to just go on. Things were very slow. Now, in fact, recently a lot of judges have been appointed in the Bombay High Court, so there are multiple benches that are now hearing 34s. So I see a lot of things moving in future. But yes, 34 jurisdiction has been predominantly slow. Things are yet to sort of change in that direction in Bombay. But the law is very straight. I mean, I'm sure
Right.
Rishabh will
And
say.
correct, correct. The only problem or the challenge which we have really faced is one that, I mean, say you have you have an excellent arbitrator, you have parties which are, you are not, they are not really laboring upon even the evidence stage, and they are asking questions which are to the T, and there is absolutely no delay. Parties are abiding by the timelines of procedural orders, etc. But say suppose your award comes within a period of 9 months from the appointment, the very moment, I mean, you can't, as you said, that can anybody file a 34? I mean, of course, an aggrieved party within the time period can file a 34. Nobody can stop him, even if the grounds are absolutely not of 34 also. The mere filing of that section 34 can't really be stopped. And that is, of course, approached as a decree of the court, and a losing party is ordinarily asked to deposit the money, etc. But all that said and done, The challenge which we face is many a times the hearing or the decision on that 34 application, which of course is something again, because arbitration, they say that lesser interference from the courts, but ultimately the moment the arbitration concludes, you have to come back to the court, and then you are again back into the system. So that whole you aspect of delay in determining matters, etc., even if a judge has to today dismiss an application, he has to at least hear both parties, because that is how, and rightly so, our law is made. So in that sense, that very time of when a party is allowed to or permitted to argue his case, and the other party is permitted to argue, the time that is spent on it and the time that it takes for a matter to come up as per its turn, is something which is something which is worrying and which needs to be worked into. Because you may get the award today, and rightly so, you may win an arbitration, but until the award is upheld, or until it goes in that fashion, you may not be able to perhaps be able to execute it. So that is one thing which is somewhere a challenge. And in
Like
terms
it's
of
very
courts
similar.
approaching it, I think they are right.
Sorry to interrupt. In fact,
Sorry,
to
Rohit, you were
add,
saying something.
yeah, to add up, it's the story of post award is very similar in India to any decree, because getting maybe a decree or an award especially is much easier. The real challenge starts after it's been passed, because by the time you really are able to enforce it, execute it, you are going to face multiple levels. In arbitration, you'll face a 34, a 37, an SLP. Uh,
Correct.
in a decree, you'll of course see multiple levels of appeal till the Supreme Court. So the real challenge actually starts after an award, but that's not Bombay specific. That's, I think, pan India, and it's not just arbitration
Country
specific.
specific. Right.
It is irrespective. It is irrespective. But still, the Supreme Court, I think, every 6 months is cutting one branch of, chopping it and narrowing it down. There we keep seeing judgments that even now this is gone. Now even this is gone. So it's narrow, but now it's again, it's on your, it's some amount of luck it plays in.
I can
Right.
just
And
tell.
one thing I
Yeah, yeah, please.
sorry to take your time. One thing which Rohit really spoke about is, I think, is of immense clarity for litigants, because he's underscored a very important point. That is who is your arbitrator. See, the law in 34 is such that today, and they say that the view of the arbitrator should be a possible view. Now, interpretation of a contract, many a times both sides is a possible view. So what parties really need to understand is that having an arbitral award is like, going to that in olden times, the panchayat system, where you accept the decision. You say that, no, they feel that this is correct, you accept the decision. You cannot tomorrow challenge it that, no, my view was also possible. So for a party, really, two views are possible. One, that is a possible view, has been taken by the arbitrator. The other party may feel that, oh, why has my submission not been accepted? And that party may very well be very justified, in those moral sense, to say that, I could have also won it. The arbitrator could have held in my favor. So that is something which will not be interfered at the stage of 34. That is something which Rohit has really underscored, and it's very important, because parties and clients are really need to, they need to understand this, and they need to gauge this, that the moment you are going to the arbitrator, therefore you are reposing complete faith, and you are sealing your own matter, unless of course it's without jurisdiction and without all of those grounds, and you're not getting into that. But that is something which parties need to embrace and really need to practically apply. And tomorrow, they can't really come forward and say that, no, he has said this, but look at this, my submissions were also cogent, my submissions were also really not incorrect. So that is something which takes time for, and it's all easier said than done. The losing party is always feeling sorry at the end, but that's something which has been done to cut judicial interference, and that really, I mean, there's no solution to that. So that
I
is
sort of
something which is important.
I compare, wills, the testamentary, the wills to an award. Once you have a
Right.
probate granted in a will, it's game over. You're virtually out. It's same with an award. Once you have an award, it will 90% stick. There is very narrow scope of that you're gonna able to flip it or turn it. Of course, things are evolving. You may keep seeing new law, but it's difficult. And whether that's good or bad, I don't know. Because I have seen situations where, a party which was actually right but did not really get the correct interpretation, so it can go both ways. But overall, of course, if awards are not set aside pro arbitration, it helps the system, economy, etc. Yes, but I don't know. It's not always good for people. It can go wrong also.
Right.
Yeah. On a lighter vein, again, I can tell both of you are Bombay boys because for the last 1 hour, you have said nothing but good things about the Bombay arbitration ecosystem. And wherever there was some shortcoming, you mentioned that this is happening all across pan India. So my next question is actually forcing you to criticize about the Bombay arbitration system, which is actually happens to be the final question for this particular episode, which is that what if anything could be done to strengthen the arbitration practice further in Bombay, which can be improved, which is not the case as of now.
I feel personally one of those things, as we rightly mentioned, and with some sort of happiness when we started by saying that there are councils appointed as arbitrators. Practically, what me and Rohit both have encountered is that there are awards reserved for months on an end. And what is the laxity over here is that today you have lawyers, every lawyer perhaps on the original side or even on the appellate side who practices in civil law will be doing arbitration, but you will not have a arbitration dedicated bar. What you have as arbitrators today are either retired judges or perhaps lawyers who are also doing arbitration. So me and Rohit, we do all sorts of matters. Perhaps Rohit specializes more in civil matters, but so today you take him for a suit, he will argue that suit. You take him as an arbitrator, he'll be an arbitrator, he'll also appear before a tribunal. But there is absence of an arbitration dedicated bar, which in my understanding and with utmost humility, I see that there are two very visible shortcomings. One being that counsels as arbitrators or even lawyers as arbitrators prioritize court to arbitration, and of course court is, of course, you have to prioritize it in terms of course the hierarchy. But what you do is you take up a matter, say tomorrow or on a coming Monday, you will be having an arbitration effectively which will be from 5 o'clock to 7 o'clock. This will be done in most cases where lawyers as arbitrators are appointed. Judges, of course, have a different, in most times, they have a different mechanism of working. They say we will sit at 11 o'clock, rise at 5 o'clock, because we are now only doing arbitration. They are arbitration dedicated or opinion work for that sense. So that is something which does, but in most cases, you will see lawyers really giving somewhere a stepmotherly treatment to arbitrations, wherein it will be held in the evening session after everybody is tired, after everybody is sort of had their own good or bad days in court, and they are doing it for carrying it forward. The second is, of course, as suppose as a counsel you're appointing somebody as an arbitrator, the hard reality, and of course you said since you've asked us to criticize, we see that the hard reality is that counsels are prioritizing their own matters which they have to argue, or own drafts which they have to settle, and not those awards which they have to write. So as a result, we have seen awards being reserved for numerous months, and I think this is touched upon with the Delhi High Court, where they've said that 6 month time, because in court as lawyers, when your award order is not uploaded, you immediately start getting a little itchy about it, and why is my order not come out, and it's so urgent, and it's this and that, and after waiting for a week or two, you feel, oh, the order is still not uploaded, it was reserved 2 months back. So as arbitrators, also as counsel, they need to have that sense of accountability where within a maximum period of at least 6 months the awards need to come out. So that is something which has to be done, and I feel that people should not really shy out, and there should be an arbitration dedicated bar. People feel that all the glory is in the High Court, but that's not really true. I mean, if you are a master of trial, or if you are a master of what you are doing in arbitrations, there should be people who should exclusively be practicing in these domain areas. So with that, it would somewhere help to sort of help in that easy disposal of cases, and also parties would be at ease. So that's something which I see as a shortcoming.
I think procedurally, possibly streamlining things. For instance, it's difficult to get interim reliefs in an arbitration. Like even if the arbitrator, sort of writes an order quickly, it's a task. I mean, for an arbitrator to write an award and an order. Let me also sort of, in all fairness, it's not easy to write an award. It's not easy to write an order. But interim reliefs now, urgency is urgency. Sometimes, third party rights are created, etc. To stop that, when you're in an arbitration, you have to file a 17. A lot of times, 17 takes a lot of time because, an arbitrator will give the other side an opportunity to file a reply. There may be a rejoinder, weeks will go by, etc. Then by the time an order comes, it'll take some more time. A lot of times parties don't obey those orders. They go and whatever breach those orders. Then what do? You go and contempt jurisdiction before the High Court. Now you go to contempt jurisdiction before the High Court, or you go in execution before the High Court. Again, you're back in the same system where you are clogged. Your turn will come after quite some time. So to make it a more effective machinery, maybe a slightly separate system for interim orders or urgent applications in that sense can be carved out, and some sort of consequence can be imposed on a party who doesn't sort of follow the orders or comply with the orders, because parties are allowed, and say for instance disclosure, an arbitrator will say disclose your assets, may not give an injunction on the first instance. Even for disclosing assets, they will file affidavits which will be incomplete, etc. What do you do in such cases? It becomes infructuous. The entire exercise of any interim relief is of no use. It's of vain. So maybe streamlining that, but again, you'll accuse me of being biased, but this is pan India story. I don't think so. This is only Bombay's problem. This can be any and everywhere. So, and I mean, why would I regionalize arbitration at the end of the day? As you said, from any city, any town, you come into Bombay, or from Bombay we go to any other place. So it's a systemic problem, I would say.
Yeah. Yeah, and I think the main takeaway from this episode can be that if you are contemplating, which I mentioned at the outset, if you are contemplating Bombay as a seat of arbitration, then it is a perfect seat to have for a variety of reasons that both of them mentioned. And if you're contemplating a career in Bombay just in dispute resolution, then again you will have opportunities which Bombay usually open up in many other industries other than just the legal industry, and not just in capacity of a counsel, but also also as an arbitrator in institutional arbitrations. So far as the questions are concerned, I think we have discussed everything that we intended to discuss. All that I have to say now is that thank you so much for both of you taking the time. And if there's any concluding remarks that you may have, then you please, the floor is yours.
No,
No,
thank
no,
you,
we are
thank you.
very thankful to really come forward and for you to give us an opportunity to come forward and speak. And it's absolutely great. Whatever you've been doing, I've seen your other episodes also, and I'm extremely thankful and grateful to be called here.
Yeah, I just want to say something to you, Rishabh, which is that you were extremely articulate throughout the episode. Like you understood the question very well and you answered it point blank the way it was supposed to be answered. And it just goes to show that years of experience does not equate how meritorious you are as a lawyer. And for you to be appointed as an arbitrator in institutional arbitration such as MCI just goes to show that you have a great career ahead, if I may say so. Rohit, if you have something to
Thank
say.
you, sir.
No, it was nice, good fun to talk to you and share our thoughts on the realities of arbitration in Bombay and how things work. I mean, it's a good place. I'd encourage anyone if they want to pursue arbitration in Bombay as a career. Nice to talk to you and share our views.
Thank you so much. And we look forward to hosting you again in the near future.
Thank you.
Thank you.